There's an old saying that someone cut off their nose to spite their face. Its origins are quite sickening, but the point is good. Back in the Middle Ages, cutting off someone's nose was an actual punishment by the state, believe it or not, and sometimes people did it to each other for revenge. This expression is about doing it to yourself to describe a needlessly self-destructive overreaction to a problem. It's a warning against lashing out against someone in a way that would damage yourself more than the person you're trying to hurt. We don't use this saying too much in our time, but it seems like it fits Blake's situation so well. In this episode, we're going to start off with an explanation of the various types of law that will be considered in this case and what that means for it. We'll move on to a discussion on anti-SLAPP laws, how they're viewed throughout the states and in federal court. Then we're going to look into 47.1, how it was meant to be applied, how it's being misapplied in this case, especially in the light of these amicus briefs, and how that could potentially affect whether or not the court considers it. Finally, we'll end with a short history of its actual birth from Bill 933 to its establishing as 47.1 in the California State Code of Laws. This case is in a federal district court. We start our little history lesson here of what the rules of this kind of court are and how we got there, because it can get kind of confusing when you have to deal with several different sets of laws. First of all, in a federal district court, there are two types of laws that must be considered. Laws that are considered procedural, which fall under federal civil procedures, and laws that are considered substantive, which fall under state codes of law. When you're dealing with a diversity case like this one, it may fall under multiple state codes, with some of these lawsuits falling under New York law and others falling under California law. So that gives us the federal district court laws and two state codes that we'll have to consider going forward. How do these coexist in these cases? And most importantly, how are they distinguished? Here's a reference chart that I made to help explain. So the procedural things about the trial will fall under these federal civil procedures. The purpose of these is to govern how a case moves through the legal system, where the state codes define rights, duties, and legal standards. The federal determine the process and timing for resolving the claim, things like deadlines, how motions are to be filed, where the state's concerned with whether a valid legal claim exists and what must be proven. The focus of federal is the how of the case, how the court and parties proceed. The focus of state codes is the what happened, and whether it's legally wrong. The procedural elements are rules for pleadings, discovery, motions, and trial. For state, the legal elements for each cause of action. That means that it's the particular state's codes that's going to be given to the jury when it's time for them to determine whether or not the person is guilty of these causes of action and what the punishments should be. The legal source of procedural is the federal rules of civil procedure, the federal rules of evidence, and local court rules, such as those put in place by Judge Lyman himself. The state codes consider statutes, common law, and constitutional provisions. Remember, each state has its own constitution. Procedural applies to procedures for enforcing or defending those rights in court, and the state, the rights and obligations between parties. The remedies governed in procedural is how a remedy is reached through trial, motion, appeal, etc. We're going to talk a lot about that today. And the state's more concerned, again with the what instead of the how, what remedy a party may receive if they win. For example, damages, injunctions, and so forth. And the last one, for procedural, the examples are things like filing deadlines, motion practice, discovery rules, and admissibility. And notice the motion practice mentions specifically 12b-6. We've learned a lot about that because remember, that's the federal guideline for determining a motion to dismiss. We are going to talk about that one a lot today. And state deals more with things like breach of contract, negligence, discrimination, and civil rights claims. Now we can think of this like any kind of sport. There are two laws that the players have to follow. One, for example, is soccer. The official rules are put out by FIFA. That's the main organization. We can think of that as the federal rules. They're the most important, and they're the actual rules of the game. But players also have to follow the coach's strategy and goals. These are a different set of rules. The coach decides, for example, who gets to play, what role they get to play, who's offense, who's defense, what plays they're to play under this game. They have their own sets of penalties. But above all, whatever's decided by the coach has to be in compliance or under the rules of FIFA. Because of this sort of dual power court, a case tried in federal court can have a different outcome than the one tried in a state court. Naturally, as people saw that, a problem arose of something called forum shopping. Attorneys would sniff out which court would be more beneficial to their client, and therefore themselves, and would seek out that court. This also led to unequal administration of the law, because diverse citizens could remove state actions to federal court and potentially take advantage of more favorable laws, thus disadvantaging litigants suing in their home state. We're going to go through some landmark cases that change things, but even still today, we do see some forum shopping. For example, for my Murdoch crew, if you followed along with the Buster case, we saw the case removed to federal court and Buster fighting with all his might to bring it back to his local Hampton County court. This idea factors in big with this 47.1 rule in this case. I think that that's one of the big reasons that all of these organizations have latched onto this case, because it's not just the big public attention that this case is getting, but the fact that it's in a federal court. Right now, this rule is only valid in California, but if they can get a favorable ruling in a federal court as a precedent, then they can possibly extend its use in federal courts around the country. So winning this case would be huge for them. This is the biggest landmark case that established this rule. Though it's approaching 90 years, its effects are still very present today. Prior to 1934, federal courts around the country applied state rules. This meant that federal courts were not unified, not connected. Rulings were very inconsistent with one another. So in 1934, something called the Rules Enabling Act took place. This unified all federal courts underneath the U.S. Supreme Court. But that was just the beginning. As I mentioned, forum shopping had become a problem. So this case, Erie Railroad Company versus Tompkins, went a long way into fixing this problem. Tompkins was injured when he was walking near a set of train tracks, and something that was protruding from the train gave him a smack. He was a citizen of Pennsylvania, but the Erie Railroad Company was incorporated in New York, so we had a diversity case. The accident took place in Pennsylvania. Now, if federal common law applies, Erie is liable. But if Pennsylvania common law applies, Tompkins was considered a trespasser, since that was the law of the state. Walking next to train tracks was considered trespassing. That would mean that because he was breaking that law, that Erie was not liable. This was just the kind of case where one decision would be more favorable than another, and would likely result in forum shopping. So what this case decided is that the concept of federal common law in diversity cases was to come to an end. Instead, the state where the accident occurred would become the substantive law. Under that rule, Tompkins is a trespasser, Erie is not liable. So if we think back to that chart with the difference in procedural and substantive, or federal and state, this is the case that created that difference. We now refer to this as the Erie Doctrine. It established that federal courts must apply the substantive law of the state where they are located, or where the harm occurred in the case of defamation. This is why in this particular case of Wayfarer versus Blake Lively, the topic of jurisdiction is a big one. We've seen them fighting over which jurisdiction each piece of the lawsuit falls under. For example, the New York Times wants New York, others want California law. The trouble happens, though, while trying to decipher which laws are procedural and which are substantive. This line can get blurry. One aspect of this was cleared up a few years later in Sabak v. Wilson in 1941. An accident occurred in Indiana, but the defendant was from Illinois, so it became a diversity case that was held in federal district court. The judge granted a request by defendant and ordered a physical examination to prove Sabak's injuries. Sabak refused to go, citing that it was not a state law in Indiana that she had to comply with. The district court charged her with contempt, so she took it to the Circuit Court of Appeals, who affirmed the district court's decision based on Federal Rule 35 that allowed for the exam. The U.S. Supreme Court granted cert, which means that it granted her writ of certiorari, which is a petition to be heard by a higher court when a person is dissatisfied with the lower court's ruling. In order to qualify for this, at least 4 justices have to determine that this case is important enough to warrant their review. And just to give you an idea, the U.S. Supreme Court only hears about 80 cases of the 8,000 applications to them per year. In their decision in this case, they reasoned that Congress had the power to regulate federal court procedures and could delegate authority to the courts to establish procedural rules such as Rule 35, which was designed to facilitate the court's ability to discover facts relevant to the case. This was decided to be procedural. Their findings in this case we often hear quoted. They found that Rule 35 did not abridge, enlarge, or modify substantive rights. You'll hear that sentence a few more times today, and noted that a court ordering a medical examination under the Federal Rules of Civil Procedure are truly procedural, and they found that this fell under the judicial process for enforcing rights and duties recognized by substantive law, and for justly administering remedy and redress for disregard of infraction of them. This was really just the beginning of navigating through laws to determine whether they are procedural or substantive. This navigation still comes up from time to time today, and is likely an issue in this case with 47.1, as we'll see in a moment. But the key from this case is the sentence, Federal Rule 35 did not abridge, enlarge, or modify substantive rights, and so it could be seen as procedural, which we've learned federal procedure takes dominance over state laws, as was established in Erie. Now, even as we looked at that chart earlier, we could see the potential for some of these to be murky, because the answer may not always be clear. And so federal courts have struggled with the question of whether a law is substantive or procedural. One of the tests that was born through Guaranty Trust Company versus York in 1945 was that one of the ways to determine this question was to consider whether the law has the potential to determine the outcome of the litigation. For example, in this case, the U.S. Supreme Court was concerned with whether disregarding a state statute of limitations would significantly alter the outcome of the litigation and cause the situation that Erie tried to correct of forum shopping. The events began in 1930, 7 months after the Black Thursday stock market crash. The Von Swearingen Corporation borrowed $30 million and issued promissory notes in return. Guaranty Trust Company was the trustee to protect the lenders. In 1931, Von Swearingen defaulted on their loan. Guaranty Trust, though they were supposed to protect the lenders' interests, bought back promissory notes for less than their value. Now, most lenders took the financial hit and bought them back for the smaller amount, but some did not, and they brought a class action lawsuit. They said that Guaranty breached their duty to them. Guaranty sought summary judgment, claiming that the statute of limitations was expired. The Southern District of New York granted the summary judgment. When the case came before the Court of Appeals, however, the Court of Appeals said that federal law trumps state law and reversed. Now, in this case, when it was appealed to the U.S. Supreme Court, they decided that the state law on the statute of limitations is in fact substantive, and they overturned the Court of Appeals decision, reaffirming the decision of the trial court. This case made it important to consider outcome when trying to determine whether something is procedural or substantive, because this would have caused a large divide between cases fought in federal court and state court, which was one of the main reasons the Erie Standard was created to stop the chance of forum shopping. A third landmark case that was really important was Hanna versus Plumer in 1965. This was a case where federal rules said a lawsuit could proceed, but the state statute says it couldn't. Now, this is a huge difference between the two, and so it had to be considered. The U.S. Supreme Court granted cert because of this threat to the goal of uniformity of federal procedure. So Hanna was in an accident. She survived, but the negligent driver died. Hanna sued the estate of the driver and served a summons. The executor, Plumer, wasn't home, and so it was served upon his wife. Now, under federal law, This is okay, but under Massachusetts law, you're not allowed to serve on anyone except for the executor himself for a summons to be valid. Because of this law, Plumer filed a motion for summary judgment. It was granted. Hannah appealed, and the First Circuit Court of Appeals affirmed the decision. That's when the United States Supreme Court granted cert. They decided that Federal Rule 4D1 was procedural and not substantive, restating the Erie Doctrine that when there's a conflict between federal and state laws, federal procedure trumps state laws, again repeating that serving a summons is procedural and does not abridge, enlarge, or modify any substantive right. It also blocked the advantage of seeking out a specific court for these kinds of cases. I think it's kind of cool to look at this history to see why a lot of laws are set up the way that they are. And this is really how it works. A code of laws can look really good on paper, but once you get into practical application, that's when you find the need to make adjustments. And this is exactly what happened to these federal district court rules. And now we can see why they make sense. But why am I saying all of this? Because when we're talking about Rule 47.1, this very topic comes up. Is it a procedural anti-SLAPP rule, or is it a substantive state rule? This is what will need to be determined by Judge Lyman. It could be treated like a substantive rule of immunity or privilege, rather than just a procedural mechanism, which could improve its chances of being applied in federal courts that usually reject anti-SLAPP motions. But this is untested so far. And more on that in a moment. Let's first talk about anti-SLAPP rules. Traditionally, anti-SLAPP rules are not upheld in federal courts, with the exception of the Ninth Circuit, which includes California. The Second Circuit in New York, which is where our current case lies, does not. Why? Remembering from the landmark cases we discussed at the beginning, it comes down to whether or not there's a conflict between the procedural and substantive rules. Anti-SLAPP rules are procedural, and they conflict with federal rules of civil procedure. And we've learned that if there's any kind of conflict between procedure from state rules and procedure of federal rules, federal always wins. But forgetting about federal courts, even the states can't all agree on anti-SLAPP law. Currently, only 35 states have one in place. Minnesota had one that it struck down in 2017 based on a case of mobile diagnostic imaging versus Hooten. This case declared them unconstitutional because they said it deprives the non-moving party of the right to a jury trial by requiring a court to make pre-trial factual findings to determine whether the moving party is immune from liability. And this is the argument that most opponents of anti-SLAPP laws consistently argue. A new revised version of anti-SLAPP, though, was reinstalled in 2024, and that's what brought the number back up to 35 amongst the states. Probably because of all this inconsistency between the states, Congress has not yet passed a federal anti-SLAPP law. Not only that, courts haven't been able to come to an agreement about their application in federal court. So at the moment, it's very inconsistent. This chart lists why they're problematic from a federal court perspective. We must remember that in federal court, federal rules govern all procedure. As we've learned, because anti-SLAPP laws overstep state substantive process and venture into procedures, they are incongruent with federal laws of procedure. This clash will always end up with federal rules winning. Two of the main clashes are with Rule 12b-6, the one we've heard so much about because it's about motions to dismiss. These are procedural, and this rule's standards are what must be met in order to grant a motion to dismiss. The anti-SLAPP rule doesn't allow for this, with the demand for dismissal before discovery. That's a clash. Additionally, we have Rule 56. We haven't gotten to that in this case, because this is something that comes up after discovery. In what situation? Let's say there just wasn't enough evidence collected to support one side of the suit. The other side, at the end of discovery, can file for what's called summary judgment, saying, "Judge, there's nothing here. This will never hold up in court. Let's not waste the time. Can we just end this now?" Much like a motion to dismiss, it's a motion that gets filed before the court with this legal argument supporting it. The judge will look at the reasons, and he'll make the determination of whether it needs to proceed to trial or not. Based on this Federal Rule 56, This is all very clearly procedural. So, anything from a state law that says, no, we don't even get to arrive at post-discovery, we want it dismissed before that, is simply incongruent with Federal Rule 56, and therefore incongruent with federal procedure. So federal procedure must win, overruling anti-SLAPP laws. Another part of federal rules includes fees as procedure, and we see this clashes here as well. Under federal rules, the only reason you would have attorney's fees for the defendant is if the case was found to be frivolous. But in these anti-SLAPP rules, fees become mandatory. We have a clash. When it comes to burden shifting, under federal rules, no. Under anti-SLAPP rules, yes. It shifts the burden to the plaintiff to prove their case early. Again, we have a clash. This is why federal courts do not uphold state anti-SLAPP rules, and probably why the Supreme Court will not even entertain ruling on these cases so far. Up to date, they have not taken any of these cases on. It would be very hard to enforce a ruling that not all states even have as a rule. This would be forcing anti-SLAPP rules by federal courts onto states that don't even have such a law, and so it simply cannot exist at this time. Now here's where we have something important for this case. There's something in law called stare decisis, which means, in Latin, to stand by things decided. This standard is very helpful when it comes to consistency. How this is put into practice is that the lower courts must rule according to decisions made by higher courts. What that means is once a court makes a decision or a ruling on a legal matter, that it sets a precedent for future cases with similar circumstances or facts. Now, if we're talking about lower level courts, that's not the case. This is only applicable when it's made by higher courts. So, for example, once something has been decided in the Court of Appeals, all of the district courts in its circuit, only its circuit, when they have similar cases come up, they must, whether they agree with the decision or not, make that same ruling. There are some ways around it, but that's not the topic of this episode, so we'll save that for another time. Now, when it comes to the Supreme Court, once they make a ruling, their ruling affects the entire country, basically. All of the courts of appeals, when they have a case with similar circumstances or facts, they must, whether they agree or not, rule in accordance with what the U.S. Supreme Court ruled. Why are we talking about this? Because a decision has been made in the Second Circuit about the California anti-SLAPP statute. In this case, the Liberté, a California resident who spoke at a city council meeting, was photographed speaking to a teenager. This photograph was later put in a meme, and the allegation was made that when she spoke to this boy, that she spoke to him using racist insults. Now, this was distributed by celebrity commentator Joy Reid. La Liberté brought this in a diversity lawsuit in the very circuit where the Wayfarer versus Blake trial is taking place. The case was dismissed for lack of malice, and it was struck under the California anti-SLAPP statute. The case was appealed. The Second Circuit vacated the judgment and remanded for further proceedings. They held that as a matter of first impression within the circuit, that California's anti-SLAPP statute is not applicable in federal court because it conflicts with the federal rules of civil procedure 12b-6 and 56, like we just looked at in the chart. The court explained that when the federal rules conflict with other procedural statutes that answer the same question, the federal rules control unless they violate the Rules Enabling Act, which the court held that Rule 12 and Rule 56 do not. The court opined that both the anti-SLAPP statute and the federal rules answer the same question, the circumstances under which a claim may be dismissed before trial. They conflict because they apply different standards, as we saw in that chart. In particular, the anti-SLAPP statute's requirement that a plaintiff establish a probability of prevailing on the merits. The court held that it imposes a more stringent standard than do Rule 12b-6, which requires a plaintiff to state a claim to relief that is plausible on its face, and Rule 56, which permits a plaintiff to proceed to trial by identifying any genuine dispute of material fact. In so holding, the Second Circuit joined the 5th, 11th, and D.C. circuits, which have issued similar rulings regarding other state anti-SLAPP statutes. and departed from the First and Ninth Circuits, which are the only two so far that have upheld anti-SLAPP statutes. Now there's more to this ruling, but it's concerning other matters, and we're on this specific subject. But the point is, the Second Circuit has already ruled on the use of anti-SLAPP statutes in federal court, specifically California anti-SLAPP. And this circuit is not alone. There's no higher court ruling since the Supreme Court has not yet ruled on this. Meaning that if 47.1 is determined to be an anti-SLAPP statute, Judge Lyman cannot accept it in his ruling because he's bound by stare decisis. So the big question that Judge Lyman has to face is whether he views this rule 47.1 as anti-SLAPP or as procedural or substantive. If it's procedural, there's a conflict. If substantive, there is not. But another important point is where we are in the stream of this lawsuit. And this will come into play here too, which complicates matters. But we'll talk about that a little bit more later. What could help 47.1 be approved in federal court? Proponents will argue that it's not procedural, that it's substantive, because it's about privilege. And these are generally respected in federal court. But opponents will say Blake is using this new rule to rid herself of the counterclaim for defamation by means of a motion to dismiss. She hopes that it creates privilege for her communications regarding sexual harassment, regardless of their truth or intent. But 47.1 clearly bars its use for malicious claims, or claims that are not factual. So the way in which she's applied 47.1 makes it procedural. We already learned that motions to dismiss are procedural. We also know that 47.1 clearly bars its use for malicious claims. Proving malice requires demonstrating that the defendant intentionally or recklessly caused harm. That requires both evidence or discovery and a trier of fact, either the judge or a jury or both. 47.1 itself, if we look at 47.1b, it clearly says a prevailing defendant. Prevailing is winning. That means the defendant has to win first. In any defamation action brought against that defendant for making a communication that is privileged under this section shall be entitled to, and then it gives the amount about the damages, for successfully defending themselves in the litigation. This is the framework of this rule. Nothing in this rule says that you can use it as a motion to dismiss. The words are clear. A prevailing defendant, you have to win. Successfully defending themselves in the litigation, you have to take it through the trial. Blake is using 47.1 not merely as a privilege defense. That would be substantive. She's asking the court to apply it as a mechanism for immunity and early dismissal via her motion to dismiss. This is what all of the authors of all of those ridiculous amicus briefs are asking for, but this conflicts with the federal rules of civil procedure. Why? Because motions to dismiss fall under procedural law. Federal rules of civil procedure govern motions to dismiss in federal court. Two of these cases we went through, Erie and Hannah, both support that. So these amicus briefs, actually from a legal standpoint, hurt her argument. Since it's supposed to be, as we saw, awarded for a prevailing defendant of a defamation claim, if it's used that way, it would help her if she wins. But this way that they're asking the court for makes it procedural. And as a procedural motion which falls under federal rules and doesn't recognize anti-SLAPP, instead of substantive as a privilege, it's her own and these organizations' faulty application that they're requesting of the court that changes it from substantive to procedural and something that the court must rule against, as this type of anti-SLAPP has already been ruled on by the Second Circuit Court of Appeals. She cut off her nose to spite her face. And now we're going to talk more about malice like I said we were. This rule requires a factual determination as to malice that cannot be decided on a motion to dismiss. 47.1 only applies to communications made without malice, and where the speaker had a reasonable basis for believing the harassment or discrimination occurred. In this case, genuine factual disputes remain about the existence of malice and the scope of privilege. The existence of factual disputes about whether Blake acted with malice or exceeded the privilege scope precludes dismissal or immunity before trial. Blake bears the burden of proving the privilege's requirements, including the absence of malice, to invoke 47.1. We have a standard set forth called the Iqbal standard. Now, we've talked about this standard in a previous episode some time ago, but this is the standard that federal courts use to decide whether a complaint is strong enough to go to trial. If they are, the case must go forward, meaning that Wayfarer gets their day in court by this standard. What has Wayfarer done to show whether a complaint is strong enough to go to trial? They've alleged and supported with evidence that her statements were knowingly false and made with reckless disregard for the truth, negating the privilege. Now remember, courts must assume the truth of well-pleaded allegations on a motion to dismiss. Also, the issues are factual, and therefore they must be resolved at trial and cannot be dismissed early or with summary judgment. And why do I say that Blake has turned this into procedure? By both her own motions and by her acceptance of these amicus briefs, and that's already been stated in one of those filings, that it's being done with her consent. This is how they've turned it into procedure. The methods they've attempted to apply create mechanisms for early dismissal. They also create mandatory fee shifting and treble damages. These are all procedural. Courts in the Second Circuit have repeatedly held that California procedures do not apply in federal court because they conflict with the established standards in Rules 12 and 56, and additionally, fee awards. The Rules of Enabling Act forbid application of state rules that abridge, enlarge, or modify procedural rights. Remember that sentence from before? 47.1 does all of these things. So while the court may recognize the privilege as substantive law, it should refuse to apply its procedural remedies. Another point in this case is that discovery posture matters. At this point, the parties have exchanged pretty extensive written discovery. We don't know this for fact, but at this point, they've probably already conducted some depositions, or at least scheduled them. I would venture to say some have been conducted because we know the deadline for them to be finished is mid-August, which is just over 2 months away. They've already presented letters and motions to the court regarding certain discovery. Not only that, the court has ruled on them. Another thing they've completely disregarded is that anti-SLAPP statutes all have time limits to file in court. They're applying this as an anti-SLAPP statute, and as one, these are well past those dates. Allowing any kind of anti-SLAPP type action would unjustly prejudice Wayfarer's right to develop a full and factual record on malice, truth, and harm, and that goes against the standards set in La Liberté versus Reed that we already considered. Another way she's misusing 47.1 is that she's not just using it as a defense, but she's trying to use it as a sword to silence Wayfarer's lawful counterclaims. In my opinion, this law could be a very good law, not just for women, but for anyone who's a victim of things like sexual harassment. What it's lacking is fairness and harmony with constitutional rights. It simply needs to be amended to include a requirement that it cannot be used as a motion to dismiss action, even in California, without a thorough investigation being held by the Civil Rights Department or the EEOC or even a neutral third party. So like in Blake's case, if she wants to be able to have this all disappeared before she has to prove anything, she should have had an investigation completed with results that she can show to a court to prove that she's a victim. Otherwise, if used in the way she's trying to have it used, it's denying constitutional rights of the accused. But is that what 47.1 states? Or is it just this grossly misconstrued meaning that Blake's attorneys and all of these organizations who file these amicus briefs have put on it? I noticed a lot of these people that are claiming to be the one who drafted it and or championed it. But let's watch the birth of this bill, 933 as it was called then, that became 47.1. You're going to meet the two authors, and you're going to hear the purpose of this bill is not what Blake's attorneys or these organizations are claiming it to be.
She's been very patient.
Good morning, Mr. Chair and members.
I'm here to present AB 933, joint authored by myself and my joint author, Assembly Member Chris Ward. First, I would like to thank the committee staff for their thoughtful analysis and for working with my staff and the sponsors on amendment language. I am pleased to amend the bill today and accept the committee amendments suggested by your staff. This bill protects survivors of sexual assault, harassment, or discrimination for stepping up and speaking out against their abuser. It is imperative that we use our power as legislators to protect them from ever having to experience sexual assault, harassment, or discrimination under our watch. Members, an act of sexual assault is committed every 68 seconds. And I want to stress that sexual violence does not just affect women. It happens to people of every gender, identity, age, and sexual orientation. The survivors are our family, our friends, the staff who support our every accomplishment, and other members of our communities, including our extended Capitol community. As you know, the halls of this very institution have not been immune to the unlawful, unwelcome, and toxic culture of sexual assault, harassment, and discrimination. We must do better. The MeToo movement gave many assault and harassment survivors the opportunity to bravely join countless others in sharing their stories on a national platform in solidarity. However, while survivors courageously came forward, many were served with defamation lawsuits by their abusers. Defamation lawsuits have become the weapon of choice by proprietors to intimidate, punish, and silence their accusers. Existing law makes certain complaints of sexual harassment privileged and protected from civil defamation actions. However, these protections are limited and leave survivors potentially open to defamation lawsuits if they engage in certain forms of speech. AB 933 will protect survivors of sexual assault, harassment, and discrimination by clarifying that claims made in good faith are a form of protected speech. Our expert attorneys and advocates have spent countless hours working on this language to ensure that the protections in this bill empower and encourage survivors to continue speaking out about their own experience in a safe and protected manner. By exposing these predators, we can prevent them from reoffending. And that means that our staff is safer, our families and neighbors are safer, and the public is at large safer. With me today to testify in support is Beth Mora, a defamation law expert from Mora Employment Law, and Pamela Lopez, a survivor, a friend, and a courageous member of our Capitol community. Thank you.
First witness.
Thank you. Good morning. Thank you, Chair and members of the committee. My name is Beth Mora, and I am here on behalf of California Employment Lawyers Association, a co-sponsor of this bill. I have been representing employees for 22 years, victims of sexual assault, sexual harassment, and gender discrimination in the workplace. I am here in strong support of AB 933, which will help prevent the abusive and retaliatory defamation lawsuits that I see all too often in my practice. This bill will simply make it clear that when a survivor speaks out about sexual assault, harassment, or discrimination, this is privileged speech. Under current law, this kind of speech is often protected under Civil Code 47, but because there are some gray areas, this can leave survivors open to attack by perpetrators. For example, Ms. Lopez, Ms. case here, that the trial court mistakenly found that her statements at a press conference did not fall within the protection of fair and true reporting privilege under the California Civil Code Section 47B. This privilege applies if substance of the communication captures the gist or sting of the statement made in an official proceeding, in Ms. Lopez's case, a legislative proceeding. Ultimately, the Court of Appeal reversed this decision and held that her statements to the press did fall within the Section 47B because her statements to the press would reasonably be understood to refer to the allegations in her complaint to the Assembly, and there was a fair and true reporting. Although the court ultimately upheld Ms. Lopez's speech as privileged, she had to endure years of litigation, and many survivors are simply unable to take on that cost and emotional toll of such a lengthy and costly litigation. In my practice, I sadly have represented numerous clients who have experienced horrific and traumatic sexual assault, sexual harassment, and gender discrimination in the workplace, who are then re-traumatized by claims of defamation brought by perpetrators specifically designed to silence them. These are victims who have lost their jobs, who have then lost their benefits, who hire attorneys on contingency fee, who cannot afford to pay for this, who are re-traumatized, sometimes worse, by the defamation. It is truly horrific. And then they are silenced. in a way that are truly more victimizing than you can even imagine. We have not made progress with MeToo. We are more back behind wherever we started. AB 933 will ensure survivors in sexual assault, harassment, and discrimination are adequately protected for defamation lawsuits by clarifying that claims made in good faith are a form of protected speech. In doing so, the bill would make it harder for perpetrators to retaliate against survivors with legal threats and intimidation. The protections in this bill will help encourage survivors to speak their truth and expose the behavior for those who are harmed. If we truly want to empower and protect those survivors who speak out, clients they deal with so often, I truly urge you to support this bill. Thank you.
Ms. Dixon.
Thank you, Chair. It does take a lot of courage. I admire your courage. I just have some clarifying questions. When Assemblymember, you mentioned made in good faith. Is that the definition? Is a comment that was made in good faith? Did I hear that correctly? Or who said that?
It has to be made without malice, and it has to be made a good faith or reasonable belief.
Because if it was made or determined made with malice, then it's subject, it has different legal.
Right, it has to be made with malice, yeah.
Okay. All right, thank you very much.
Mr. Saley.
Just briefly, thank you, Mr. Chair. I appreciate you being here. I know what courage it takes to speak publicly, and we sympathize with that. I will tell you, I'm a new member here, so luckily, I guess I wasn't, part of the prior culture. From my understanding, there have been advances. I mean, to say that MeToo hasn't resulted in benefits. I mean, there are reforms here at the legislature. I know in orientation, I received a lot of training on this subject. Weinstein's been convicted of multiple counts now. Bill Cosby was convicted. So I do think there's been some positive effects of this movement. One of the concerns I have is balancing the need to obviously empower and protect victims, but also with protecting innocent people who might be falsely accused. And that's also very traumatizing to be accused, slandered, or and have your life and reputation. I think the best example is what happened to the Duke lacrosse players, who were accused of rape, and that turned out to not be true, and their whole lives were destroyed and turned upside down. So my concern about the bill is you're creating basically blanket immunity for statements on this topic. And by elevating it to the public figure status, which requires malice, it's almost impossible to win those cases. We know that. You can just look at slander cases involving public figures. So my concern is that by having blanket immunity, there's not really going to be a deterrence to people making reckless accusations. Malice is very hard to prove. Yeah. They could just say, I made a mistake. I didn't remember clearly. And so that's my concern with the bill is it's a balance, and we have to protect victims, but also protect the innocent.
Well,
Now notice only this one man voices any concern for people who've been falsely accused. And I blame this on the timing that it came out right after Me Too, and nobody wants to seem like they're going up against Me Too. But it's a valid concern.
just add, Assemblymember, and thank you for your comments, that I am aware that I have been the subject of malicious and defamatory comments after I stepped forward. Every survivor who's ever made the decision to step forward after experiencing sexual assault takes that decision very heavily, because we know one of the first things that's probably going to happen to us is either to our face or behind our back a lot of, I don't mean to say an off-color word in committee, but a lot of SLUT shaming, right? That's one of the reasons that people don't step forward. And so I have never even had it occur to me that a defamation lawsuit is an opportunity to protect my reputation, even though I know that my reputation was in peril after I was sexually assaulted and I did absolutely nothing wrong. So with regard to defamation lawsuits, I would just point out that, this is absolutely man or woman, whatever your gender orientation. I hope that the average working Joe doesn't identify with these rich and powerful people who file these defamation lawsuits, because that is a rich and powerful person's game. Regular people like me, we don't have the money to put up defamation lawsuits anyway if somebody is speaking badly about us in a way that can be damaging to us. So I hear you, but the way that the practice actually plays out, it's very much the Weinsteins of the world who abuse these cases.
And I feel like that's a really good point, good question, sir, and I think you've made some valuable points. I also would like to acknowledge that in every case I have to warn the person who's looking at the case about the risks of participating. And that is not just that you're going to be challenged and shamed, but it's also that there's fee shifting. If you bring a frivolous lawsuit, they can come after you for fees and costs for
Right,
sexual harassment.
Yeah.
No, not just with the SLAPP motion, sir. But the court can order you to pay the defendant their fees and costs. So there are safeguards and rails put in place for bringing a frivolous lawsuit. And so the defamation claims are actually now things I have to warn plaintiffs about, saying, not just do I have to warn you that if you bring a frivolous lawsuit or a lawsuit that's even just kicked out, there can be fees and costs that you would have to pay. Now they might sue you. And what's happened is this massive chilling effect. That's what we're talking about silencing and taking us backwards. It's the fear and the guardrails of fees and costs for FEHA claims existed already. What's happened with the defamation claims is now people who would speak before are so terrified of being sued because they can't afford to defend them that they're not speaking at all. That's what we mean about going backwards.
I appreciate that and understand. I think my concern is that this is just it says blanket immunity. It's kind of broad, and so maybe there's a narrow way to address this. But I hear you. I appreciate the comments. It's a difficult issue. It's a difficult balance. But thank you, Mr. Chair.
Any other questions or comments from the committee? Seeing none, thank you, in particular, Ms. Lopez. Thank you for your testimony.
And again, I want to thank you, and I want to respectfully ask for your aye vote.
Thank you. The motion is to pass as amended. Ask clerk, please call the roll. The motion passes. Thank you. Ms. Wilson, you have.
AB 933, the clerk will read.
Assembly Bill 933 by Assemblymember Aguiar-Curry and others enact relating to privileged communications.
Assemblymember Aguiar-Curry, you may open.
Madam Speaker and members, I rise to present AB 933, legislation authored by myself and the gentleman from San Diego. AB 933 will protect survivors of sexual assault, harassment, or discrimination who speak out against their abusers. The MeToo movement gave many assault and harassment survivors the opportunity to bravely share their stories. However, as survivors courageously came forward, many were served with defamation lawsuits meant to intimidate, punish, and silence the very people they had abused. AB 933 will clarify that claims made in good faith are a form of protected speech. Members, these survivors are our family members, our friends, and the staff who support our every accomplishment, our neighbors, and our other community members, including the extended Capitol community. It is imperative that we use our power here to protect them from sexual assault, harassment, or discrimination. And it is just as imperative that we protect them from revenge lawsuits when they come forward to put a stop to abuse. I will respectfully ask for your aye vote.
Assemblymember Ward, you're recognized.
Thank you, Madam Speaker. I rise as the proud joint author of Assembly Bill 933. According to the Rape, Abuse, and Incest National Network, 2 out of 3 sexual assaults are not reported to police. This is disproportionately affecting California's women, our daughters, our mothers, our neighbors. It disproportionately affects LGBT community members, including gay men, and it disproportionately affects our students and our young professionals and California's most vulnerable. And why is this? Because the decision to speak out publicly about one's own experience is highly personal, and it's often made more complicated by the fear of retaliation from the abuser. That retaliation can take many forms, from physical or emotional to the growing trend of legal retaliation in the form of defamation lawsuits filed for the sole purpose of silencing the survivor. Now, this has had an immense chilling effect on survivors coming forward and speaking out, as many are unable to afford costly litigation or publicly relieve their trauma through invasive discovery processes. Allowing their survivors to share their experiences is a necessary form of prevention of future sexual crimes. So this bill, Assembly Bill 933, will not only lift up those voices of these survivors and allow them to speak their truth without fear, but it will allow them to seek justice and put an end to the weaponization of defamation lawsuits to silence them. I respectfully ask for your aye vote.
Thank you, Assemblymember Ward. Seeing and hearing no others wishing to comment on this item, Assemblymember Aguiar-Curry, would you like to close?
I respectfully ask for your aye vote.
The clerk will open. All those who desire to vote, vote. All those vote who desire to vote. All those vote who desire to vote. The clerk will close the roll. We have 59 ayes and 3 noes. This motion carries.
Well, thank you. Good afternoon, Mr. Chair, number 3. And members, I'm here to present AB 933, joint authored by myself and my joint author, Assemblymember Chris Ward. This bill protects survivors of sexual assault, harassment, or discrimination for stepping up and speaking out against their abuser. It is imperative that we use our power as legislators to protect them from ever having to experience sexual assault, harassment, or discrimination under our watch. Members, an act of sexual assault is committed every 68 seconds. And I want to stress that sexual violence does not just affect women. It happens to people of every gender, identity, age, or sexual orientation. The survivors are our family, our friends, the staff who support our every accomplishment, and other members of our communities, including the extended Capital community. As you all know, the halls of this very institution have not been immune to the unlawful, unwelcomed, and toxic culture of sexual assault, harassment, and discrimination. We must do better. The MeToo movement gave many assault and harassment survivors the opportunity to bravely join countless others in sharing their stories on a national platform in solidarity. However, while survivors courageously came forward, many were served with defamation lawsuits by their abusers. Defamation lawsuits have become the weapon of choice by perpetrators to intimidate, punish, and silence their accusers. Existing law makes certain complaints of sexual harassment privileged and protected from civil defamation actions. However, these protections are limited and leave survivors potentially open to defamation lawsuits if they engage in certain forms of speech. AB 933 will protect survivors of sexual assault, harassment, and discrimination by clarifying that claims made in good faith are a form of protected speech. Our expert attorneys and advocates have spent countless hours working on this language to ensure that the protections in this bill empower and encourage survivors to continue speaking out about their own experience in a safe and protected manner. By exposing these predators, we can prevent them from reoffending, and that means that our staff is safer, our families and our neighbors are safer, and the public at large is safer. With me today to testify in support is Beth Mora, a defamation law expert with Mora Employment Law, and Pamela Lopez, a survivor, a friend, and a courageous member of our Capital community.
Thank you, Senator Laird. All right. Next witness, please.
Thank you, Mr. Chair and members of the committee. My name is Beth Mora, and I have been representing employees for over 22 years in matters including sexual assault, sexual harassment, and discrimination in the workplace. I am here in strong support of AB 933, which will help prevent the abusive and retaliatory defamation lawsuits that I see in my practice all too often. This bill will simply make it clear that when a survivor speaks out about assault, harassment, or discrimination, that it is privileged speech. Under the current law, this current kind of speech is often protected under Civil Code 47, but because there are some gray areas, it can leave survivors open to attack by perpetrators. In my practice, I have represented numerous clients who have experienced horrible and traumatic sexual assault, sexual harassment, and discrimination in the workplace, who are then re-traumatized by claims of defamation brought by the perpetrators specifically designed to silence them. These are victims who have already shown tremendous courage by making a complaint, who have often lost their jobs, lost their benefits, do not have means to provide for care that they desperately need after suffering harassment, discrimination, and assault, who cannot afford an attorney, and often are hiring someone like me on contingency, who cannot defend a defamation claim. The often outcome is silence, fear, and they will not speak. It is extremely difficult for survivors to speak about their abuse, to even consider speaking about this abuse. And the weaponization of defamation lawsuits is a form of secondary victimization. In my practice, I am forced to warn victims of this victimization and re-traumatization. And then the result is they now sit in fear and consider not speaking at all. These claims...
Thank you. If you could wrap it up.
Thank you. With AB 933, we will ensure survivors of sexual assault and harassment and discrimination are adequately protected from defamation lawsuits and clarify that the claims made in good faith are a form of protected speech. If we truly want to ensure...
Thank you very much. I appreciate your testimony. All right. All right. All right, let's bring it back to committee for questions. Questions? Comments? Seeing none, is there a motion? Senator Ashby moves the bill. All right. Assemblymember Aguiar-Curry, would you care to close?
I would just like to respectfully ask for your aye vote. You've been through a lot this afternoon, and thank you very much for your attention. Appreciate it. And I'm just, helping out my friend here as well as others under defamation law. Thank you so much. And to be brave takes bravery. And we saw bravery earlier in this. This is a place that you got to make sure you have a brass backbone, let me tell you. Thank you very much.
All right. Thank you. All right. Madam Secretary, if you'd call the roll.
You have 8-0 with members missing.
8-0, we'll put on call. Thank you.
Please read.
Assembly Bill 933 by Assemblymember Aguiar-Curry and Act relating to privileged communications.
Senator Rubio, the floor is yours.
Thank you, Madam President, and ladies and gentlemen of the Senate. I am proud to present AB 933 by Assembly Speaker Pro Tem Aguilar Curry and Assemblymember Ward. This important bill will protect survivors of sexual assault, harassment, or discrimination when they step up and speak out against their abuser. We must allow them to speak up without fear. An act of sexual assault is committed every 68 seconds. AB 933 will protect those survivors by clarifying that claims made in good faith against their abusers are a form of protected speech. AB 933 also expands protections to include cyber sexual bullying to protect students and our young folks who far too often experience this form of sexual abuse. A sexual assault happens to people of every gender identity, every age, every sexual orientation. It could be any of us. Colleagues, by exposing these predators, we can prevent them from reoffending and keep our families, our neighbors, and the public safe. This bill has no opposition. I respectfully ask for an aye vote. Thank you.
Is there any discussion or debate on this item? Any discussion or debate? Seeing none, this item is eligible for unanimous roll call. Very good. Please call the roll. If there's ayes 31, noes 5, the measure is adopted.
You may open.
Thank you, Madam Speaker and members. AB 933 is back on concurrence. This bill will protect survivors of sexual assault, harassment, or discrimination from weaponized defamation lawsuits. Amendments taken in the Senate expand protections to include survivors who experience sexual abuse on online platforms. I respectfully ask for your aye vote.
Seeing no others wishing to speak on this item, the clerk will open the roll. All those vote who desire to vote. All those vote who desire to vote. All those vote who desire to vote. The clerk will close the roll. Ayes 46, no 0. Senate amendments are concurred in.
If it's left in the courts as it was written, that malice first has to be proven not to exist, and that the defendant must have prevailed in court, it would be okay in that sense, because those things alone should be able to rule out any sort of malicious counterclaims that are simply put there as retaliatory. But if it's going to be misapplied and ruled on the way that Blake is asking for it to be ruled on, this is a very big concern indeed. So there you have it. That was the original application of this bill by the two authors, and as you can see, it's quite different from what Blake is asking the court to do. So, by asking for too much, by asking for this misapplication of this rule, has Blake ruined its applicability for herself? Has she cut off her nose to spite her face? This all hinges on Judge Lyman's decision. This is Cassidy O'Connell saying stay well and stay tuned.